Mr. Gillespie, I'm sorry, go ahead, Ms.
SJC-10362, Scott versus Garfield.
Good morning, Mr. Gillespie.
Good morning, Your Honor. Your Honor, may it please the Court, my name is Paul Gillespie. With me is Kristen Morgan. We represent the defendants, Stuart and Ellen Garfield. And unless the Court would like me to give a recitation of the facts, I will begin with our first argument.
That would be fine.
The first argument I'd like to address is the issue of the extent that breach of warranty of habitability extends beyond the tenant and eventually to the tenant's guests and his lawful visitors and to members of the general public.
Can I ask you, it was just puzzling to me, why is that an important issue in this case where the jury found both negligence and injury due to a breach of implied warranty, same conduct, two theories, one set of damages? What difference is it going to make?
One major difference is that there was comparative negligence found on the negligence count,
Okay.
to the extent of, I believe it was 20% of the damages, and that is quite significant.
Did you make an offer of proof at trial of what you would have shown regarding the columns?
It was discussed at an evidentiary hearing with Judge Murtaugh. We had expert testimony available which would have shown that there was no rotting at the end of the railing piece, and therefore, because it was missing on the railing piece, even though the column was discarded, the condition of the railing, the end of the railing, would have demonstrated there was no rotting in the column, and that was we were prevented from offering that evidence by our expert, Mr. Harkness.
Going back to the implied warranty of habitability, if we have said in the Maillet case that the implied warranty of merchantability is not limited by privity, why should there be a different rule for the implied warranty of habitability?
Well, Your Honor, I believe that the cases seem to repeat. There's a blurring between contract and tort on this type of case, and I think policy reasons even that we're getting to the same point with two results. The best demonstration of that was the question on comparative negligence. If you've got the same condition, you've got the same injury, the same parties, and with that one major exception of comparative negligence, really you're arriving at the same result after this determination.
But would that change the obligation of a landlord? I mean, generally in negligence there has to be knowledge of the defect. Does that mean that then that an absentee landlord would be better off in a world without implied warranty because the less he knows, the better?
Well, I think that there's, in fairness to the landlord who's given this burden, there should be some requirement of notice to the landlord. Now, in our case today, at the time of the letting, there was no defect, and that was demonstrated by an occupancy permit given by the City of Lynn, and it was only after the tenancy commenced and the landlord didn't have the same opportunities as he enjoyed before the letting. That it seems that notice is a very important issue to him.
Would you say, let's say that the person injured was Ms. Baker and not Mr. Scott.
Yes.
Would you say that there would be no liability under the implied warranty because of lack of notice, or wouldn't it apply?
I'm saying in this instance, the lack of the notice requirement didn't arise until after the tenancy was in progress.
I understand that.
And in fact, the jury in the case found that as a fact, that there was that the defect arose
But
after the...
doesn't the implied warranty suggest that you have an obligation to keep it up to standards throughout the tenancy?
Yes, but to be fair about it, the landlord has to have a way to find out if the property is being degraded or deteriorating.
I thought there was evidence
Yeah.
on that subject.
There was some evidence of that, which was there was never a concession by the landlord that he actually saw a deficiency in that porch. So
I understand there was no
it was never
concession, but
conceded.
I thought there was some evidence on this very point, and maybe I'll ask your brother counsel to elucidate us a little bit on that.
But
So-
what, putting the notice question aside, so returning to Justice Gaines's question, as a policy matter, why wouldn't society want the landlord to keep the premises safe? Again, I'm putting notice aside. What difference does it make whether we're talking about a guest or the tenant?
Well, I think the thrust of that is again back to comparative negligence, and you know, there are cases where the if warranty is to be contractual, it seems to me that it gets very remote in places where the contractual relationship exists. For example, a moving person brought in, or a paper boy, that kind of thing. It gets very remote from where the actual contract starts.
Do we have to go that far, Mr. Is it your position that if we say it extends to a guest, it extends to anybody, the public, uninvited or invited?
Yes.
That's your concern?
That's one of my concerns, yes, Your Honor. It just doesn't seem, if the language in the reported cases talks about a contractual relationship being important, being relevant, then you get some very remote plaintiffs out of that scenario.
So what you're saying, is this right, that the contractual relationship justifies, or can be seen to justify, the lack of comparative negligence being an element?
Well, that's,
But once you leave that contractual relationship, why should you get to a place where the landlord, who is liable under negligence, should be sort of strictly liable in that sense?
well, the difference is comparative
No,
negligence.
that's what I'm saying. I'm saying, is that's your argument?
Yes.
Yeah.
It seems much more fair.
Turning to spoliation, what do you say our standards should be with regard to spoliation?
In this instance, it seemed to us that the trial judge, had made up his mind that there was spoliation before the evidentiary hearing. That's what we're complaining about. And the standards, I suppose, is three results possible. You have spoliation by intent, spoliation by negligence, or no spoliation. It seems those way it should come down. To have that decided before any evidence is put in, I thought was objectionable.
Well, why do you say it was decided? He decided to have a hearing, and he had a full evidentiary hearing on
But
the
in
subject.
the context of that, before the hearing commenced,
I take it that in the motion, the plaintiff's motion here, there was a sufficient showing that there might be spoliation, that a hearing was warranted. So it's not surprising the judge may have said that. May have even said, I think it requires an explanation.
well, on page 27 of our brief, if I can find the reference here, here it is. This is from Judge Murtaugh before the hearing. It says the question here is why wasn't the column preserved? Spoliation certainly existed. Now, this is before anybody said anything. We also
Well, he may have said that, and he may have been using the term in the sense that important evidence has disappeared. It's gone. It was destroyed. And then he has an evidentiary hearing about all of the circumstances. Why isn't that? I mean, are we going to blame him because he says something at the beginning that I think there's sufficient evidence of spoliation that we ought to have a hearing?
My interpretation, for what that's worth, was he had already decided that, and then, subsequently we put on a, and by the way, and shifted the burden to.
Well, I wanted to ask you about shifting the burden. I know you complain about that, but isn't there sort of automatically there has to be burden shifting in spoliation cases because it's the alleged spoliator, I guess that's the word, who controls both the evidence and how he got rid of it. So doesn't the burden have to shift?
Our argument was, or is, that the burden is on the party raising the point. In this instance, it was the plaintiffs who accused us of spoliating something.
Okay, well, you said you couldn't produce it. So doesn't that at that point shift the burden to you to explain why?
No, well, we did. We attempted to.
No, you may have explained it. I'm not saying that you didn't, but I'm saying isn't it proper to put the burden on the defendant when the defendant doesn't produce it?
My take on it is that the party asserting that has the burden of going forward with
But they
proof.
don't have control. They don't have any information.
They had all
They
kinds.
said produce it, and you said no. Well,
in,
you can't. I can't. So how can they?
in point of fact, they had more information than we did, in a sense, because she was a guest of the tenant who controlled the premises. The woman who.
But she moved out. I mean,
So she moved out.
At the point of discovery, the tenant was long gone. It was you had control.
The tenant was still in control of the premises about, I think, maybe 2 weeks after the happening of the accident.
But hold on. But
This work
I mean, your
wasn't-
client took the columns down and disposed of them. It wasn't the tenant,
No, ultimately he did. Yes, you're right, Your Honor.
right? So I mean,
No.
And it was
I don't know
after
how
she'd left.
And it was sometime after she left, probably a month or so after the accident.
So he's in control of the property. I mean, I don't see why it's wrong to put the burden on you. As I say, you may have met it here, but it's you who have control of the item.
Well, we were partially in control of it. The tenant had it for at least a couple of
Okay,
weeks,
tenant has a
and,
couple
and
of
then
weeks,
then we acted after that. But
Mr.
the plaintiff in the case there was something unusual happened. The plaintiff's lawyer was a guest at the party, called my client, the defendant, a couple of days later and said, "I demand you give me the railing only."
Mr.
And,
that goes to the question I'm here. That goes to the question I was going to ask you, which is, when were you put on notice that the plaintiff wanted the columns?
We never were before trial, or
So it
was-
seems
was-
to me
was
if we think
years anyway.
if we think outside of this, I'm thinking of another context. Somebody says, I want all of the documents about the relationship between this employee and you, the employer, and you keep those documents. And then sometime then the other documents are destroyed. Sometime later, the plaintiff says, actually, I want the documents that pertain to all of the employees in this section of the company. And you say, those have been destroyed. Right?
Okay.
I think that's what you're saying here. Who has the burden?
There's a
And
similarity there, yes.
yeah, and you say it's not my burden unless you can show that I intentionally did that, which I didn't. And how could I be negligent if I always had a right to destroy my documents? And unless you've put me on notice and I know it and it's not intentional because the secretary threw them out by mistake, there's no spoliation. Am I correct in understanding your argument?
Yes, that's exactly our point. We did what we were asked to do, and we weren't
Unless
negligent.
you could say it was so obvious, the connection between the item that is not available any longer and what you were asked for.
Well, it's a balance of power issue, too, where the plaintiff's lawyer is making this request through a relatively unsophisticated landlord, and he does exactly what she asked for.
To go back to Justice Gantz's initial question on spoliation, if we're trying to set a standard, I take it that you would agree with me that if the defendant or defendant's counsel is on notice that plaintiff or plaintiff's counsel is looking for something, you would say in this case the railings, you would say, and if those railings disappear, or in the judge's words, are critical evidence no longer available, I take it you would accept in those circumstances that the burden might be on you, or maybe would be on you.
That's quite possible, I suppose, yes.
But if you're not on notice, and you're saying you never will put on notice that the columns...
Not about the columns, just the only demand was for the railing, which we had at all relevant times and which we made available.
Wouldn't you say, though, let's say Ms. DeBartolo hadn't made that call, but there's clearly an accident. I think that your client did call his insurer right away, and and he knew that Mr. Scott was badly injured. So there is a certain recognition that there's likely to be a claim here. That's why he called the insurer.
No doubt.
So apart from the lawyer saying save the railing, isn't our case law, doesn't it suggest that it could certainly be found that when you reasonably knew or should have known that there's likely to be a claim, that evidence that may be relevant to that claim, and it would be both the columns and the railing because one was attached to the other. In other words, apart from her, it would seem to me that there is a pretty strong case for a finding of certainly not intentional, negligent spoliation.
Well, the point, too, is that the plaintiff had the opportunities to do all the inspections they wanted to do. They even photographed the area immediately after the accident, the day of it, as a matter of fact, and that we complied with what they asked us to do. And I don't see how that can be interpreted, I agree, as intentional, and certainly not negligent.
I'm sorry, you said the plaintiffs came out and inspected the porch?
The plaintiffs were there at the time of the accident.
Right, of course.
And their friends and guests photographed the connections.
Didn't your client also inspect the columns and make photographs of the columns?
He made a photograph of the scene in general. He never made an effort to specifically photograph the columns.
Okay.
So.
Thank you, Mr.
Okay,
Gillespie.
thank you, Your Honors.
Good morning, Mr. Heyman.
Good morning. May it please the Court, my name is Tom Heyman, along with Frank Powell. I represent the plaintiffs' appellees, Charles and Pamela Scott. And we urge this Court to affirm the judgment entered by the trial court in favor of Mr. and Mrs. Scott.
Why isn't negligence the right claim here? It may be that the landlord is held to a standard relating to habitability, but why isn't negligence the right standard?
Negligence is one right standard. It's simply not the only right standard, Your Honor.
But there's no, you're not living there. Your client's not living there. They're a guest. Any landlord has an obligation to take reasonable steps to ensure not only the safety of the common areas, but the safety of areas that have been leased for residential purposes. But shouldn't that be the standard?
I respectfully no, Your Honor, and I believe there are 4 good reasons supporting the majority of trial court decisions in this area for extending the warranty of habitability to the protection of guests of residential tenants.
Okay.
First of all, contrary to Mr. Garfield's argument, the contract is not the source of the warranty of habitability. Of course, you need a contract, but the warranty of habitability doesn't arise because of a promise or because of any mutual understanding between the contracting parties.
It's the codes, the safety codes for
Exactly.
residential.
It's the code, and as this court determined first in the Hemingway case, by operation of law, the warranty of habitability is imposed upon the landlord as a result of the lease relationship. And therefore, since it's imposed by law and it can't be waived, it can't be discarded, it can't be modified, there's no reason to limit the benefit of the implied warranty of habitability solely to the contracting parties.
So anybody, even if they're not a guest, for example, someone breaks into the second floor apartment and falls off the porch.
I think that certainly not this case, Your Honor, but at least with
I
regard
was
to
hoping you would say that.
with the logic of what's the obligation imposed by the landlord by the warranty would apply in all circumstances.
Would you not say, excuse me, Mr.
Excuse me. Go ahead, Chief.
Would you not say that it's by operation of law imposed, not as a basis of the contract, but an operation imposed by law on anybody that the landlord permits to be on the premises, and implicitly when you enter into a lease with a tenant, implicit in that is that the tenant will have friends, and unless, I mean, for example, there are leases which say you can't have, as long as you're allowed to do it by law, you know, you can't have guests after midnight or something like that. But in the absence of that, a lease implies that a tenant can have any invited guest, and that's the extent of the implied warranty of habitability.
Exactly, Chief Justice, and that's one of the other of the four reasons I'd like to mention. Looking at the issue from the landlord's perspective, the landlord knows, or certainly is charged with constructive knowledge of the requirements of the sanitary code. The landlord knows he has to keep the leased premises during the term of the tenancy fit for human habitation and meeting the minimum requirements of the building and sanitary codes. He also knows, because the sanitary code says so, that the purpose of the sanitary code is to protect not only occupiers of land and tenants, but also the public. And so he knows that preventing conditions that arise that would violate the sanitary code is something that he needs to do for the protection of public, and not
What
just...
what about the obligations of members of the public? I mean, just because the implications of this are that someone can come to your tenant's home, get completely drunk out of their mind, do terribly negligent things, maybe be 100 or 90% negligent, but because the railing was defective, the rules of negligence don't comply, comparative negligence doesn't apply, and
Just
I mean,
too
how
bad.
is that fair?
Too bad for the old landlord.
I think that's right, Your Honor. And
Why?
I think that rule has been established in Hemingway and its progeny. These obligations have been imposed upon the landlord and to comply with the sanitary code and keep the premises safe, fit for human habitation. It shouldn't, he has that that's an obligation that he has relative to how he takes care of his premises.
All right, so it's a public policy, but you're saying it's essentially public policy. It's so what? Landlord has the obligation, regardless of how guests may act, it doesn't matter. As long as it relates to something having to do with the habitability of the residence. But what about the notice question here? The jury found that this place was fine when it was leased. There was no problem here. There was no breach of any warranty of habitability. So what was the evidence that the landlord was on notice that there was a problem that had to be fixed?
There was abundant evidence. Most importantly was the evidence that came from the spring of 2000 when the landlord, Mr. Garfield, acknowledged explicitly that the porch, including the railings, actually two porches, were in poor condition. They needed to be fixed, and he planned to fix them that summer of 2000, and then he didn't do so. There was other evidence back from 1995 and 1996 where Mr. Garfield told one of the tenants, Brian Dozer, not to allow his girlfriend to sit on the railings because they weren't safe, and then he had Mr. Garfield fix another railing on that same porch, which Mr. Garfield did fix but he didn't check the other railings.
Okay.
And the jury necessarily found, Your Honor, that Mr. Garfield knew or should have known about the defective condition of the railings, and that's exhibited by the fact that they did find him to be negligent. And obviously
Okay.
those...
I have a question on another subject. Why should the judge have given the instruction that he did that the plaintiff might be required to repay some damages awarded to his health care insurer?
We have to keep that instruction in mind with the context of all of the judge's instructions. And throughout the course of the trial, insurance issues came up with regard to Mr. Scott's health insurance. There was a question from a juror. The trial judge repeatedly instructed the jury that insurance was to have no
Right.
place in their deliberations.
Right, but that's why what raised the question in my mind. Having instructed the jury all along on that, then why should the judge say, bring in the issue of insurance?
Didn't that paragraph come right after something where it said even whether it's repaid or not?
That's right. He was, what the trial judge was trying to do was to convince the jury in all ways to not consider whether Mr. Scott had insurance benefits. And I think that Judge Murtaugh saw that comment as a way to mitigate his recognition that the jury really had insurance on its mind. And the other issue, Justice Cowan, that relates very importantly to Your Honor's question is the issue of prejudice. And in this case, the special damages exceeded $200,000. The jury award for Mr. Scott's damages was $450,000. There has been no argument made at the trial, in the post-trial motions, or on appeal by Mr. Garfield that the award was excessive. He did not request a remitter. So even though that comment doesn't necessarily come out of the MCLE book on jury instructions in the Superior Court, there's really no doubt that on this record the comment was harmless.
One question, and perhaps maybe you can inform me on the facts. This question about whether the defendant could have produced or should have been able to produce evidence of what was actually paid to the medical providers, not the bills they sent. We all get these bills that are wild, and then we find that our insurer has a contract in which they pay 30%, and the rest of it presumably is there just for show. I mean, it's no reality at all.
Several comments, Your Honor. First of all, Chapter 233, Section 79G allows medical bills and medical records to be introduced as part of the determination of the fair and reasonable cost of medical services.
I don't disagree with that.
Prima facie, the bills are admissible for that purpose. Finding out that a lesser amount was paid because Mr. Scott happened to have health insurance is something that the jury is not supposed to know about because of the collateral source rule. Mr. Scott...
But so who gets this money that wasn't paid, that's being awarded for medical damages that never were paid? I'm just trying to figure this out. Does the hospital have any recourse? The hospital has a contract with the insurer to accept 30 cents for this dollar procedure, so the hospital doesn't have any right to get the additional 70 cents, but you get to claim it as medical damages. So you get to keep money for medical damages that was never expended.
That's exactly right, Your Honor. And as this Court has observed, if there's going to be a windfall as a result of some arrangement between an insurer and a health care provider, the windfall should go to the party who's been injured, not to the party that caused the injury.
Now, I assume if we view it differently, then you'd have to offer evidence for each medical bill as to what the share of insurance was, and there could be 3 or 4 different insurance companies, and if it was Medicare, you'd have to deal with Medicare or Medicaid too, I would think.
We'd have a trial within a trial, Your Honor. And also, again...
Well, wait a second. That's interesting. I mean, I get a bill all the time for medical. It says, here's what the hospital charged, here's what we pay under our contract, and that's it. So you know what is paid, you know what's charged. And one's 30% of the other.
But the only way to establish that fact in evidence is to inform the jury about the existence of insurance, which is something we don't do. Also, relative to that issue, again, the question on this record of prejudice. Remember, Garfield did not argue or produce any evidence that the amount of the medical bills introduced in evidence was unreasonable. And he didn't make any offer of proof to show what the evidence would have been if Judge Murtaugh agreed with his suggestion that we should just know what the insurance company paid. So on this record, there's no basis to conclude that any prejudicial error took place with regard to that collateral source issue.
On the issue of spoliation, you said that the original attorney for the plaintiff said she asked the defendant to save the railing because she knew it was in the debris on the street and she assumed the column would be preserved because it was part of the house. But why does that make sense? Because the plaintiff's attorney knew the railing was all damaged and they'd have to be repaired. So the column very likely might have to be repaired at the same time. It was going to be repaired to the railing. Obviously, she knew that. So how can she assume that the column wouldn't be repaired at the same time?
Ironically, Your Honor, although the accident occurred in 2002, Mr. Garfield didn't replace that railing as of the time of the trial in 2006. However,
okay, but I didn't ask that.
No,
That's not an answer to the question.
the columns remained structural portions of the porch. They were holding up the roof above. There was no reason for Ms. DiBartolo or anyone else to assume or
No, but when you get a repairman in to do work, they always start doing something, you know, oh, this is bad, well, now I see you have to fix that too. So how could she assume that when she knew there was damage to a part of the porch that much more of it wouldn't be repaired at the same time?
The facts just didn't suggest that there would be any reason to take down the columns, unless, of course, there was something...
I didn't say take down. I just said make some repair. When somebody's repairing one thing, they see another thing, and that has to be fixed at the same time.
But we have to keep in mind what the law of spoliation is in the Commonwealth, and the law requires someone in Mr. Garfield's position who's aware of a potential claim to recognize what evidence may be relevant to that.
Well, how is he supposed to recognize that that was important evidence if she didn't recognize it? You're saying both things at the same time.
Well, let me just add a modification to that. Let's assume that's true if she hadn't said anything. But when she says, save the railing, doesn't that put him in a slightly different position? Because now somebody has spoken and identified specifically what she wants. So how's he then supposed to, is it negligent to say, that's what I thought she wanted, I saved it?
No, because the duty is on the person in control of relevant evidence to preserve it. And that duty, under case law of this Court, has never been affected.
But you assume the conclusion. How does he know it's relevant evidence? She didn't think it was.
Well, he thought it was because he went out and examined it, and Judge Murtaugh found that he was interested in figuring out why the railing had detached from the columns. And also, the standard is an objective one. It's a reasonable person in Mr. Garfield's position. Would such a person have thought that the columns might be relevant to Mr. Scott's claim?
But I guess all I'm saying is would a reasonable person in Mr. Garfield's position, after having been specifically asked to save the railings, think that the columns are also relevant? I mean, she adds a different, sort of fact into this mix here.
She does, Your Honor, but nevertheless, a reasonable person in Mr. Garfield's position would conclude that the columns were important because we had an accident, a serious accident that occurred because an entire railing detached at both ends from the columns. And an objective person, without regard to what had been asked by Ms. DiBartolo, it would occur to such a person to think, boy, those columns might be relevant, and maybe I should...
They might be, but could you go to the hypothetical that I gave to Mr. Gillespie, which really goes to Justice Botsford's point. Let's say we have a gender discrimination suit, and the plaintiff asks, I want all the records of my evaluations, payments made to me, and so on and so forth. Business has routine document destruction every 3 years. This court has routine document destruction every 3 years. paralegal, in-house counsel says, save those documents. Reasonable person, this is a gender discrimination suit. Aren't they going to look at least the other women in the department? I mean, it seems to me once a demand is made, that you really change the equation. I don't know, I just don't know sitting here. I haven't looked at the pictures. I don't know what this railing looks like. But at the railing, it seems to me that there are lots of reasons why a railing, which may be of a different material, would be loose because there's some defect in the railing. It may not occur to me that it's also the column.
In each case, in the case of employment records, we're going to have to just use the standard that's well established by this court, and the trial judge will apply it and be reversed only for an abuse of discretion. And so whether it's porch columns or other employment records, the trial court judge is going to assess whether a reasonable person in the position of the person in control of the evidence would conclude that that evidence might be relevant to the potential claim.
Boy, that's going to put a lot of businesses in a very nervous situation.
But in the case of employment records,
Well, no, they don't have to be employment records.
Right.
Anything where you have routine upkeep of a building. Every 3 years we paint the building. A reasonable person should have known that the accident, would have left paint marks. It seems to me it's a very unworkable standard for putting people on notice as to what they can and cannot do with respect to what could be evidence.
I just think that if it's part of a routine practice to do something, that's going to be a factor weighed by the trial judge. In this case, however, this is not a difficult case at all, I submit. The columns were structural pieces. They were removed and discarded within a short time after the accident, and the porch was never fully repaired. As I said, the railing wasn't replaced over the course of...
There are lots of photos in the appendix. They're all marked S. Garfield, and they're photos of the columns, etc. Whose photos are these? Whose photos are these?
Those photos, I believe, were taken by other guests who were at the site on the day of the accident.
So Mr. Garfield didn't take photos of the columns, for example.
We learned during the course of the trial that Mr. Garfield took some photos. I can't recall, Your Honor, whether they depicted the columns or not, and I'm not sure that they were included in the record appendix.
Mr. Heyman, with respect to the medical bills, were any of them either statutorily, I'm not sure that applies, either statutorily or by subscription, by subscriber, capped by the amount of insurance that was paid?
I don't think there's any evidence in the record as to that, and I'm not aware of it.
If they are capped, either by statute or by subscription, why shouldn't the reasonableness of the medical bill track either the statute or the subscribership?
I think that would be a factor for the opponent of the evidence to try to demonstrate that an amount of a bill that's been submitted is not reasonable.
But do you think that that would be an appropriate thing to be the subject of a mechanism, perhaps even post-trial?
I think it should take place before post-trial.
Before it goes to the jury, so that the quantity or the quantum of the reasonableness of the medical bills is predetermined?
I think it should be part of the body of the evidence of the case.
Well, then the jury will know that there's insurance.
Well, if I'm and I don't know the exact application Your Honor's referring to, but if we have some sort of a statutory cap, and if there's...
If you accept, if the provider accepts insurance, they cannot collect the difference between the amount billed and the amount paid. There are...
Balance billing.
Balance.
Then I still think that that's an arrangement that exists between carrier and insurer for the benefit of someone other than a defendant that caused a personal injury, and it probably should not come in. But that wouldn't preclude a defendant in those circumstances from trying to marshal any other evidence to suggest that the amount of the medical bills being submitted is not reasonable.
Now, I gather here that the defendant did not seek to offer anything at trial about this.
No,
Is
he
that
did.
correct?
He did. I thought he wanted to offer evidence of what was actually paid versus what was actually
He did.
billed.
He just didn't make an offer of proof as to what that amount was, to identify a difference or to identify, to give this court any basis to conclude whether he was
Okay, but to me,
prejudiced.
there's a difference between what Justice Spina describes as offering a contract which says we will only pay 0.7 of the bill, which may go to the issue of reasonableness of the bill, versus saying, I want to know what he actually had to pay himself, which goes more to the collateral rule. Which did the defendant here seek to do?
The defendant sought to establish how much Mr. Scott's insurance carrier paid for his medical care. For all of these reasons, and the reasons identified in our brief, we respectfully request that the court affirm the judgment entered by the trial court.
Thank you, Mr. Heyman.